Papers, now. Immigration check.
Under what authority am I being detained?
Don't play games. Show proof of citizenship.
My name is Marcus Hayes. I'm a federal judge. I can provide identification.
Sure you are. Everyone's got a story.
You're making a mistake.
We'll verify that downtown.
The parking garage beneath Richmond's federal courthouse was nearly empty when it happened. Thursday afternoon, 4:17 p.m. The kind of fluorescent-lit silence that makes footsteps echo and every sound feel amplified. Judge Jeffrey Riley had just finished a marathon hearing on a complex securities fraud case. Still in his courtroom attire, navy blue suit, crisp white shirt, burgundy tie loosened just slightly, leather briefcase in his right hand. He just pressed the key fob to unlock his sedan when an ICE agent emerged from behind a concrete pillar he hadn't noticed anyone standing near. His body camera was rolling, recording what would become the most expensive 4 minutes in federal law enforcement history. Before we continue, where are you watching from? If this is your first time here, you need to hit that subscribe button. Stories like this don't get mainstream coverage unless we shine a light on them. And your support means these videos reach people who need to understand what's happening inside our justice system. Agent Milton Kinser initiated the approach. Badge number 4, 392, 7-year veteran, tactical vest over a dark polo shirt, hand resting on his duty belt near his service weapon. Riley saw him coming, registered the ICE patch, the aggressive posture, the eyes already fixed on him like a target had been painted on his back. His judicial instincts cataloged it all in the second it took Kinser to close the 20-foot distance. Federal agent, Immigration and Customs Enforcement, approaching a federal judge outside a federal courthouse, looking at him not with recognition but with suspicion. Riley knew exactly where this was heading before Kinser opened his mouth. "Sir, need to see your papers. Immigration and Customs Enforcement is conducting operations in this area. I need identification and proof of citizenship." Kinser's voice carried that particular bureaucratic certainty, the tone of someone who'd made this demand 1,000 times and expected immediate compliance. No greeting, no explanation. Just the command that would set off a chain of events ending in a $3 million settlement, a terminated career, and congressional hearings on federal overreach. Riley set his briefcase down slowly, deliberately, keeping his hands visible. 19 years on the federal bench had taught him how quickly situations escalate. He'd presided over dozens of cases involving use of force, qualified immunity, civil rights violations. He knew the law, he knew his rights, and he knew that the man standing in front of him was about to make the worst mistake of his professional life. "I'm Judge Jeffrey Riley," he said, his voice calm, measured, the same tone he used when addressing attorneys who'd stepped out of line in his courtroom. United States District Court, Eastern District of Virginia. My chambers are on the 4th floor of this building. My credentials are in my briefcase, and there are U.S. Marshals 30 yards away in the security office who can verify my identity immediately. What happened next would be dissected frame by frame, second by second, in depositions, internal investigations, and ultimately in a federal lawsuit that exposed the fault lines between law enforcement authority and constitutional rights. Kinser didn't move to verify anything. He didn't radio the marshals. He didn't step back or reassess. Instead, he squared his shoulders, his hand still near his weapon, and delivered the 8 words that would end his career. "I don't care who you say you are." The body camera captured everything. The timestamp 16/17/23. The parking garage level B2. The distance between them now less than 6 feet. Riley's expression shifting from patience to recognition that this situation was spiraling beyond reason. And Kinser's next words, delivered with the absolute confidence of someone who believed he had federal authority to demand papers from anyone, anywhere, regardless of who they claimed to be. Show me a passport or birth certificate right now, or you're coming with me. This is the story of what happens when federal enforcement power collides with federal judicial authority, and when an ICE agent, operating under vague intelligence and emboldened by an expanded enforcement mandate, decides that a federal judge's word isn't good enough. When profiling, conscious or unconscious, overrides decades of protocol, respect for the judiciary, and basic common sense. The cameras were rolling. The concrete walls of the garage would amplify every word. And in exactly 47 seconds, Agent Milton Kinser would commit an assault that would cost the federal government $3 million, cost him his career, and force a national reckoning with how federal agents are trained, or not trained, to recognize the limits of their authority. Judge Riley reached slowly for his briefcase, maintaining eye contact with Kinser. Agent, I'm going to show you my judicial credentials. They're in the front pocket. I'm reaching for them now. But Kinser had already decided this was a threat, not compliance. His hand moved toward Riley's arm. And that's when everything went catastrophically wrong. Judge Jeffrey Riley hadn't planned on becoming a federal judge. Growing up in Norfolk, Virginia, in the 1960s and 70s, he'd watched his father, a postal worker, navigate a world where respect had to be earned twice over if you were black. His mother taught 3rd grade at an all-black elementary school that didn't get new textbooks until the white schools across town had finished with them. Riley learned early that the law could be a weapon or a shield, depending on who wielded it. He'd gone to Howard University on scholarship, then University of Virginia School of Law, where he was one of 7 black students in his class. Classmates who'd assumed he was an affirmative action admission learned otherwise. When he made law review, after graduation, he could have taken the corporate track, big firm, big money partnership by 40. Instead, when he joined the Virginia Legal Aid Society, representing clients who couldn't afford representation, housing discrimination cases, employment disputes, criminal appeals for defendants whose court-appointed attorneys had phoned it in. For 15 years, Riley fought in courtrooms across Virginia, building a reputation as meticulous, prepared, and relentless. Judges respected him because he knew the law better than most attorneys twice his age. Opposing counsel feared him because he never bluffed. If Riley said he had case law, he had case law, highlighted and tabbed. When the district court nomination came in 2006, even senators who'd opposed the administration's other judicial picks voted to confirm him. Unanimous, 98-0. On the bench, Riley ran his courtroom like a graduate seminar, respectful but demanding. Attorneys learned quickly. Be on time, know your case. Don't waste the court's time with theatrics. He had no patience for lawyers who showed up unprepared or witnesses who played games under oath. But he also had a reputation for fairness that crossed ideological lines. Conservative and liberal attorneys alike knew they'd get a fair hearing in Riley's courtroom, even if they didn't like his ruling. That Thursday had been typical. A morning motion hearing on a pharmaceutical patent dispute, dry, technical, billions of dollars hanging on interpretations of claim language. Lunch at his desk, reviewing briefs for tomorrow's docket. Then the securities fraud hearing that ran until 4 p.m. 3 attorneys on each side, mountains of evidence, testimonies about shell corporations and offshore accounts. Exhausting but intellectually engaging, marked the kind of complex litigation that reminded him why he'd wanted this job. He'd loosened his tie in chambers, grabbed his briefcase, and headed for the parking garage, mentally reviewing which motions he'd rule on tonight and which needed more research. His mind was on precedent and procedure, on the careful weighing of evidence that defined his career. He wasn't thinking about being targeted, about being seen as suspicious, about needing to prove he belonged in the building, where his name was literally on the directory. That awareness came when he heard the footsteps behind him, faster than casual, purposeful. And then the voice. "Sir, need to see your papers." Agent Milton Kinzer had been hunting since dawn. 7 years with immigration and customs enforcement had taught him to trust his instincts. And his instincts told him today would be a good day for numbers. He'd built his reputation on apprehensions more than any other agent in his previous posting in Atlanta, enough to earn him 3 commendations and a formal letter from a regional director praising his proactive approach to enforcement operations. The transfer to Richmond had come during the surge, when field offices across the country were told to expand operations, increase visibility, demonstrate results. Kinzer had volunteered for the assignment. Richmond meant federal buildings, government offices, higher profile targets. It meant opportunity to prove himself in a new territory, to show that his Atlanta success wasn't a fluke. And the morning briefing had been vague in the way they usually were. The supervising agent had pulled up a map of downtown Richmond on the projector screen, circling areas near federal buildings. Intelligence suggested increased activity. That was the phrase they always used, increased activity, around the courthouse district. No specific targets, no photographs. Just demographic indicators: males mid-30s to late 50s, professional attire, possibly using federal buildings for cover. The briefing emphasized visibility, assertiveness, the need to demonstrate that no area was off limits to enforcement. Kinzer had been working the downtown grid for 6 hours when he decided to check the courthouse parking garage. Federal buildings were magnets, the supervising agent had said. People assumed they were safe near government offices. Yeah, that ICE wouldn't operate so close to federal property. That assumption, Kinzer had been taught, was exactly what made courthouse areas productive hunting grounds. He'd parked on level B1 and walked down to B2, the quieter level where fewer people parked, where someone trying to avoid attention might leave a vehicle. The tactical vest felt heavier in the fluorescent lighting, the weight of authority and expectation. 7 years of training had taught him to read body language, to spot evasion, to trust the profile over the explanation. Subjects always had stories. They always claimed to belong. The job was separating truth from performance. When he saw the man in the navy suit with the briefcase, something clicked. Wrong place, wrong time, moving with the kind of casual confidence that could be genuine or could be practiced. Unprofessional attire, but not quite right. The tie was loosened, the briefcase worn, the bearing somehow off for this location at this hour. Kinzer's hand moved to his duty belt as he stepped out from behind the concrete pillar. His body camera activated automatically. Red recording light steady. Target acquired. Time to verify status. He'd done this 1,000 times before. This would be no different. The body camera timestamp read 16/17/23 when Kinzer delivered his demand. Riley's response came within 2 seconds, calm and precise, the voice of a man accustomed to being heard and respected. "I'm Judge Jeffrey Riley, United States District Court, Eastern District of Virginia. My chambers are on the 4th floor of this building." Kinzer didn't blink. His hand remained near his weapon, his stance unchanged. "I need to see identification and proof of citizenship. This is a federal immigration enforcement operation." Riley set his briefcase down slowly, a calculated movement meant to signal cooperation without submission. "Agent, my judicial credentials are in my briefcase. I'm going to open the front pocket and show them to you. I'm also happy to have you contact the U.S. Marshal's office. It's right through that door, about 30 yards from where we're standing. They can verify my identity in less than a minute." The offer was reasonable, de-escalatory, exactly what conflict resolution training would recommend. But Kinzer had heard variations of this script before. The claim of important connections, the suggestion that someone nearby could vouch for them, the attempt to redirect rather than comply. Standard evasion tactics. "Sir, I don't need to contact anyone. I need to see a passport or birth certificate. Those are the documents that prove citizenship. Do you have either of those with you right now?" Riley's expression shifted slightly, the first indication that his patience was being tested. 19 years of managing difficult attorneys had given him exceptional control, but this was beyond difficult. This was absurd. "Agent Kinzer?" Riley glanced at the name tape on the tactical vest. "Federal judges are issued credential cards by the Administrative Office of the U.S. Courts. That's the identification we carry. It has my photograph, my judicial seal, and my signature. It's in my briefcase. May I retrieve it?" Kinzer shook his head. "A card isn't proof of citizenship. I need a passport or a birth certificate. If you don't have those documents, we're going to need to continue this conversation at the field office, where we can properly verify your status." The parking garage seemed to grow quieter, the hum of ventilation the only sound beyond their voices. Riley's jaw tightened, almost imperceptibly. "Agent, I understand you have a job to do, but I am a federal judge. I work in this building. My courtroom is directly above us. If you have any doubt about my identity, the U.S. Marshals Service provides security for this courthouse. They know me. They see me every day. You can verify my identity in the time it takes to walk to that security office." Kinzer's response was flat, rehearsed, the bureaucratic certainty of someone following protocol as he understood it. "Sir, with all due respect, anyone can claim to be anyone. I've had people tell me they're lawyers, doctors, government employees. Without proper documentation, I have no way to verify your claims. Now, do you have a passport or a birth certificate, or are we going to need to resolve this at the field office?" Riley straightened, his full height now evident, his voice dropping into the register he used when attorneys tested him one time too many. "Agent Kinzer, you're refusing to take 30 seconds to verify the identity of a federal judge. You are demanding documents that federal judges don't carry because we have government-issued credentials, and you are threatening to detain me based on your refusal to use the verification resources literally yards away from us. Do you understand the position you're putting yourself in? Kinzer's hand moved closer to his belt. His voice hardened. Sir, I'm going to need you to comply with my lawful instructions. Show me a passport or birth certificate, or turn around and place your hands behind your back. The body camera captured Riley's expression in that moment. Not fear, not even anger, but something closer to disbelief. The recognition that reason had failed, that credentials meant nothing, that this situation was about to escalate beyond words. You're making a serious mistake, Riley said quietly. Kinzer reached for Riley's arm. Turn around, now. The body camera timestamp read 16/1947 when Kinzer's hand closed around Riley's left arm, just above the elbow. The grip was tight, practiced, the kind of hold taught in defensive tactics training designed to control a subject's movement. Riley's body went rigid, every instinct telling him to pull away. But decades of courtroom discipline overrode reflex. He didn't jerk back. He didn't raise his voice. His response was measured, deliberate, spoken directly toward the camera he knew was recording. Agent, do not put your hands on me. I am a federal judge. Kinzer's grip tightened. Turn around and place your hands behind your back. You're being detained for failure to provide proof of citizenship. Riley remained still, his briefcase now on the concrete floor beside them, his free hand visible and open. You are making physical contact with a federal judge. You are committing assault. I am ordering you to release me and contact courthouse security immediately. The command in Riley's voice, the same tone that had silenced unruly courtrooms and brought contemptuous attorneys into line, had no effect. Kinzer's training had taught him that subjects often became more aggressive when being detained, that verbal commands asserting authority were attempts to regain control. He interpreted Riley's judicial tone not as legitimate authority, but as escalating resistance. Kinzer's second hand moved to Riley's shoulder, applying pressure, attempting to turn him toward the concrete pillar 3 feet away. Stop resisting, turn around now. Riley's feet remained planted. He wasn't resisting in the traditional sense, not pulling away, and not fighting. But he wasn't complying either. His voice rose slightly, projecting toward the security camera he knew covered this section of the garage. You are assaulting a federal judge. This is being recorded. I am not resisting. I am standing still. You are using force against me without cause. The body camera showed Kinzer's perspective as he pushed Riley backward. Riley's shoulders hit the pillar with a dull thud that the camera's microphone captured clearly. The impact wasn't violent enough to knock him down, but it was forceful, deliberate, meant to establish physical dominance. Riley's suit jacket bunched up against the rough concrete, the fabric pulling at the seams. Kinzer moved in closer, trying to reach for Riley's right arm to bring both hands behind his back. His tactical vest pressed against Riley's chest. You're pinning him against the pillar. Stop resisting and put your hands behind your back. Riley's breathing was controlled but audible, his words clipped with the effort of maintaining composure while being physically restrained. I am not resisting. You are assaulting me. My name is Judge Jeffrey Riley. I am a sitting federal judge in this district. You are committing a federal offense. Kinzer grabbed Riley's right wrist, pulling it toward his back. Riley's body twisted with the movement. his cheek now pressed against the concrete pillar. The body camera captured the moment in stark detail. A federal agent in full tactical gear, physically restraining a man in a business suit. The man's repeated statements of judicial authority, seemingly meaningless against the mechanical execution of detention protocol. Riley's voice was strained now. Aren't the physical pressure making it harder to speak? But the words remained clear and deliberate. You are assaulting a federal judge. This entire incident is being recorded. You will be held accountable for this. The parking garage security camera mounted 20 feet away at a 45-degree angle captured what Kinser's body camera couldn't. Riley's face pressed against concrete, his expensive suit jacket torn at the shoulder seam, his briefcase lying on the ground where it had fallen, and the growing realization in Riley's expression that he was powerless to stop what was happening through words alone. Kinser had Riley's right arm now, pulling it behind his back, reaching for his handcuffs with his free hand. Then the elevator doors opened. The elevator chimed at 16:20:34, less than 3 minutes after the confrontation began. 2 U.S. Marshals emerged onto B2, their hands already moving toward their weapons as they assessed the scene. An ICE agent pressing a man in a business suit against a concrete pillar. The lead marshal, Deputy Marshal James Vickers, a 15-year veteran who'd provided security for Riley's courtroom dozens of times, needed exactly 1 second to process what he was seeing. Kinser, step back from Judge Riley, now! Kinser's head snapped toward the voice, his grip on Riley's arm loosening slightly but not releasing. His body language shifted, shoulders pulling back, weight redistributing. The posture of someone suddenly aware they had witnesses. This subject refused to provide proof of citizenship. I'm detaining him under federal... That's Judge Riley. The second marshal, Deputy Marshal Lisa Chen, moved to flank Kinser from the opposite side, her voice sharp with disbelief. He's a federal judge. Let him go immediately. Kinser's hands released Riley's arm as if burned. Riley stepped away from the pillar, his breathing heavy, one hand moving to his shoulder where the suit jacket had torn. He didn't speak immediately, just straightened his posture, adjusted his jacket, reclaiming his dignity through measured movement. Vickers positioned himself between Kinser and Riley, his hand still near his weapon. Judge Riley, are you injured? Do you need medical attention? Riley's voice was steady despite the adrenaline coursing through him. I'll be fine, Marshal Vickers. But I want this incident fully documented. Body camera footage, with security camera footage, photographs of any visible injuries, and a complete incident report. Chen was already on her radio, calling for additional marshals and requesting a supervisor. She turned to Kinser, her expression a mixture of anger and disbelief. Agent, what the hell were you thinking? Judge Riley's been on the bench here for 19 years. His chambers are on 4. We see him every single day. Kinser's confident demeanor had evaporated, replaced by something between confusion and defensiveness. His hands had moved away from Riley entirely, now held slightly away from his body in a gesture that looked almost like surrender. He refused to provide proof of citizenship. He wouldn't show me a passport or birth certificate. I was following protocol for... He's a federal judge. Vickers's voice cut through the parking garage like a gavel strike. He doesn't need to show you a passport. You could have asked us. We're 30 yards away. You could have called courthouse security. You could have used common sense. Riley retrieved his briefcase from the ground, his movements careful, controlled. When he spoke, his voice carried the weight of judicial authority that Kinzer had dismissed minutes earlier. Marshal Vickers, I want Agent Kinzer detained until his supervisor arrives, and I want ICE leadership notified immediately that one of their agents just committed assault and battery against a federal judge. Kinzer's face had gone pale. The reality was finally sinking in. Within 20 minutes, the parking garage had transformed into a crime scene. Deputy Marshal Chen photographed Riley's left shoulder, where Kinzer's grip had left visible bruising, the marks appearing as dark, fingerprint-shaped shadows against Riley's brown skin. She documented the torn seam of his suit jacket, the fabric pulled apart where it had caught against the concrete pillar. Riley stood still for the photographs, his expression neutral, but his hands trembled slightly as he loosened his tie further. The only visible sign of the adrenaline still working through his system. Vickers had already started the incident report, typing rapidly on a tablet, while two additional marshals kept Kinzer separated on the opposite side of the garage. Kinzer stood near his vehicle. He got no longer the confident hunter, but a man watching his career disintegrate in real time. His body camera had been secured as evidence. His service weapon had been temporarily confiscated pending investigation. He'd stopped trying to explain himself after the third marshal had arrived, and immediately recognized Riley. The ICE supervisors arrived at 1647. Two senior agents in suits rather than tactical gear, their expressions grim as Vickers briefed them on what had occurred. The taller one, Assistant Field Office Director Raymond Shaw, approached Riley with the careful steps of someone navigating a minefield. Judge Riley, I'm AFOD Shaw. I want to apologize on behalf of Immigration and Customs Enforcement for this completely unacceptable incident. Agent Kinzer will face immediate administrative action and will be conducting a full investigation. Riley's response was measured, each word chosen with the precision of someone who understood that everything said in this parking garage would eventually appear in legal documents. AFOD Shaw, your agent physically assaulted me after I clearly identified myself as a federal judge. He refused to verify my identity despite my repeated requests and despite the U.S. Marshal's office being 30 yards away. He demanded documents he knew federal judges don't carry, and when I wouldn't comply with unlawful commands, he used force against me. Shaw nodded, his discomfort visible. We will absolutely be reviewing every aspect of this incident. Agent Kinzer's actions do not reflect the standards of our agency. Riley picked up his briefcase, the torn jacket still hanging awkwardly on his shoulder. His voice remained calm but carried unmistakable steel. AFOD Shaw, I want to be very clear. I will be filing a formal complaint through the Office of Professional Responsibility. I will be filing an incident report with the Judicial Conference, and I will be pursuing all available legal remedies, both administrative and civil, against Agent Kinzer and potentially against ICE for the policies and training failures that enabled this assault. He turned toward the elevator, marshals flanking him protectively. I suggest you preserve all evidence, including Agent Kinzer's body camera footage, the security footage, and any documentation of the supposed intelligence that brought him to this garage. I'll be requesting all of it through discovery. The elevator doors closed on Shaw's stricken face, and Kinzer's 1,000-yard stare. The investigations began within hours of Riley leaving the parking garage. ICE's Office of Professional Responsibility opened case file 202-6-OPR-1847 by 6 p.m. That same evening, flagged as high priority due to the involvement of a federal judge, the Judicial Conference's Committee on Judicial Security initiated its own inquiry simultaneously, treating the incident as a potential breach of judicial independence and safety protocols. 2 parallel investigations, 2 different agencies, both racing to document what had become an institutional crisis. The body camera footage arrived first. Kinzer's Axon device had captured everything from his perspective: the initial approach, Riley's calm identification, the repeated explanations, the escalating tension, and finally the physical contact. Audio analysis would later reveal that Riley identified himself as a federal judge 4 separate times in the first 90 seconds. Kinzer's response, "I don't care who you say you are," appeared at timestamp 16/18/03, preserved digitally for posterity and future legal proceedings. The parking garage security footage provided the wider angle that Kinzer's body camera couldn't capture. 3 ceiling-mounted cameras had recorded the encounter from different positions, showing Riley's non-threatening posture throughout, his hands remaining visible, his movements slow and deliberate. The footage captured the moment Kinzer grabbed Riley's arm, the push against the pillar, Riley's face pressed against concrete, and the torn jacket visible even in the grainy security feed. The video contradicted any potential claim of resistance or threat. Witness statements began filtering in within 24 hours. A courthouse clerk had been walking to her car on B1 when she heard raised voices echoing up from B2. She'd paused, concerned, but hadn't been able to see the altercation from her position. 2 attorneys who'd been leaving the building arrived at the garage elevator just as the marshals were photographing Riley's injuries. Both provided statements confirming they'd seen Riley, with visible bruising and a torn jacket, his demeanor shaken but controlled. The most damning evidence came from the marshals themselves. Vickers's incident report detailed his 15-year professional relationship with Riley, noting that the judge was immediately recognizable to any marshal or security personnel who worked in this courthouse. Chen's supplemental report questioned how an ICE agent could conduct an enforcement operation within 50 yards of a federal courthouse security office without coordinating with the marshals or checking the building's judicial directory. The ICE Office of Professional Responsibility requested Kinzer's operation logs for the previous 6 months. What they found raised questions that went beyond a single parking garage confrontation. Kinzer had logged 47 detentions in his first 3 months in Richmond, nearly triple the field office average. His reports consistently described subjects as evasive, non-compliant, or matching intelligence profiles. But when OPR requested the actual intelligence documents that had justified these operations, the files were thin, vague, often just demographic descriptions without specific identifying information. The case file grew thicker by the day. Marcus Webb filed the lawsuit in the same courthouse where Riley presided, though the case was immediately reassigned to a judge in the neighboring district to avoid any appearance of impropriety. The complaint ran 43 pages, meticulously detailed, citing violations of the Fourth Amendment's protection against unreasonable seizure, 42 U.S.C. Section 1983, for deprivation of civil rights under color of law, assault and battery under Virginia common law, and violation of judicial immunity principles dating back to English common law. Webb, a civil rights attorney with 20 years of experience taking on federal agencies, requested compensatory and punitive damages totaling $5 million. The discovery phase exposed what many had suspected. In Webb's subpoena for the intelligence that had justified Kinser's presence in the courthouse parking garage, produced a single-page document dated 3 days before the incident. The document described reports of undocumented individuals utilizing federal building proximity for cover, with suggested target descriptions. Males ages 30 to 60, professional attire, may claim employment or business at federal facilities. No names, no photographs, no specific identifying information, just demographic profiles broad enough to encompass thousands of people in downtown Richmond on any given day. When Webb deposed the ICE supervisor who'd conducted the morning briefing, the supervisor admitted under oath that the intelligence was general guidance for area operations, rather than information about specific individuals. He acknowledged that agents were encouraged to use their judgment in selecting subjects for verification checks. That phrase, use their judgment, would become critical in establishing that Kinser's decision to target Riley was discretionary rather than intelligence-driven. Kinser's deposition, conducted over 2 grueling days in August 2026, became the evidentiary equivalent of a car crash. Webb walked him through the body camera footage frame by frame, asking him to explain each decision point. The exchange that would later be quoted in the settlement memorandum occurred 90 minutes into the first day. Webb asked, Agent Kinser at timestamp 16/17/45. Judge Riley clearly states, I'm Judge Jeffrey Riley, United States District Court, Eastern District of Virginia. You heard those words, correct? Kinser shifted in his chair. Yes. And you responded, I don't care who you say you are. What did you mean by that statement? I meant that anyone can claim to be anyone. I needed documentation. Webb leaned forward. Judge Riley offered to show you his judicial credentials from his briefcase. Why didn't you look at them? Credentials can be faked. Judge Riley offered to have you contact the U.S. Marshals Service 30 yards away to verify his identity. Why didn't you do that? A long pause. I didn't think it was necessary. You didn't think it was necessary to verify whether the man you were about to physically detain was actually a federal judge? I thought he was lying. Webb let that statement hang in the air. What made you think Judge Riley was lying about being a federal judge? Kinser's attorney interjected with an objection. Yes, but Kinser answered anyway, his voice quiet. He fit the profile we were looking for. The demographic profile? Yes. Can you describe that profile for the record? Another pause, longer this time. Kinser's face had gone pale. Black male, professional appearance near federal buildings. Webb pulled out the intelligence document and placed it in front of Kinser. Agent Kinser, does this intelligence document mention race anywhere? Kinser stared at the page. No. So where did race come from in your assessment? Silence. The settlement negotiations began 48 hours after Kinser's deposition transcript was filed with the court. The Department of Justice attorneys handling the case had read the testimony, watched the body camera footage for the dozenth time, and reached the conclusion that taking this case to a jury would be catastrophic. A federal agent admitting under oath that he targeted someone based on race, ignored clear identification as a federal judge, and used physical force against that judge, despite having easy verification options 30 yards away. It was the kind of case that produced 8-figure verdicts and national headlines. The initial settlement offer came in at one point, $2 million. Webb countered at $4.5 million. After 6 weeks of negotiations mediated by a magistrate judge, they reached agreement at $3 million, paid by the Department of Homeland Security, with no admission of liability, but with strict confidentiality provisions that Riley refused to sign. He wanted the case public, wanted the deposition testimony available, wanted other victims of similar profiling to see that accountability was possible. The settlement agreement included one unusual provision that Riley had insisted upon. Agent Milton Kinser would be terminated from federal service and permanently barred from law enforcement positions with any federal agency. ICE had already placed Kinser on administrative leave, pending the investigation's outcome, but Riley wanted the termination formalized, made part of the public record. On November 3rd, 2026, Kinser's termination became official. His personnel file would forever carry the notation: terminated for cause, assault on federal official, violation of civil rights, failure to follow agency protocols. But Riley wasn't finished. In January 2027, he testified before the Senate Judiciary Committee in hearings titled Federal Enforcement Overreach and the Protection of Civil Rights. His testimony, delivered in the same measured tone he used from the bench, detailed not just his own assault, but the systemic issues it revealed. He presented data showing that ICE agents in multiple field offices were conducting enforcement operations based on demographic profiling rather than specific intelligence. He highlighted the lack of training on judicial immunity, on verification protocols, on implicit bias. And the hearing room fell silent when Riley described the moment Kinser's hands had grabbed his arm, when he'd felt his face pressed against concrete, when he'd realized that his judicial authority meant nothing in that parking garage. If this can happen to a federal judge, Riley testified, imagine what happens to ordinary citizens who don't have marshals 30 yards away, who don't have body cameras capturing everything, who don't have the resources to hire attorneys like Marcus Webb. 6 months later, Congress passed the Judicial Protection and Federal Accountability Act with bipartisan support. The law mandated implicit bias training for all federal law enforcement agents, created clear protocols for verification of credentials when individuals claimed federal employment. Waken established an independent review board for complaints of civil rights violations by federal agents. It required federal agencies to document the intelligence basis for enforcement operations and prohibited detentions based solely on demographic profiles. Riley attended the bill signing at the White House, standing behind the president as the pens were distributed to congressional sponsors. The photograph from that day shows Riley in a new Navy suit. The torn one from the parking garage had been preserved as evidence and eventually donated to the National Museum of African American History and Culture as part of an exhibit on contemporary civil rights struggles. The $3 million settlement was quietly deposited into an account Riley established for a new legal foundation, the Federal Accountability Project, providing free representation for individuals who'd experienced civil rights violations by federal agents. The Foundation's first case involved a school teacher in Arizona who'd been detained for 3 hours despite showing her driver's license and teaching credentials. Her attorney cited Riley versus United States in the initial complaint. Agent Keinzer's body camera footage became a training video, shown in law enforcement academies across the country as an example of catastrophic judgment failure. The phrase, "I don't care who you say you are," entered the lexicon of what not to do, a cautionary tale about the consequences of letting bias override verification. Riley returned to his courtroom, his chambers on the 4th floor, his parking spot on B2. The parking garage had been equipped with additional security cameras and emergency call buttons. U.S. Marshals now conducted regular patrols of courthouse parking areas, and every new ICE agent in the Richmond field office received a briefing that included Riley's case as mandatory training. The concrete pillar where Riley had been shoved remained unchanged, unmarked, just another support column in a federal parking garage. But everyone who worked in that courthouse knew which one it was. Some called it a reminder. Others called it a warning. Riley, when asked, called it a lesson about the cost of assumptions and the price of accountability.